Unfortunately, Mr. Bond could not be here today. He is out in the wilderness of Montana at the moment. But I am more than capable of helping you guys out, and I look forward to doing so. And I really do appreciate all of you being here today. All right. So to begin, I couldn't emphasize this point anymore, and I probably don't have to tell you that these are perilous times in America, especially right now, probably more so than when I've ever delivered this presentation before, with COVID and the upcoming election and really just all of the conflict going on in America right now. These are truly difficult times to really even get a sense of where this nation is headed. However, COVID affects it, but there's also just day-to-day difficulties that are faced by Americans, and no group in America is more affected by all of these issues that are going on than the elderly, the disabled, and retirees especially. And then you can only imagine if these are the troubles that we're facing now, what kind of issues our children and even grandchildren or great-grandchildren will face. It's almost really difficult to imagine. I'm sure 10 years ago we wouldn't have thought that we're at where we are right now. Just the future, you never know what it's going to hold. And so these are perilous times, and we want to help you address some of these issues. Now, one of the ongoing issues that is constantly plaguing American families is divorce. It's just a fact of life these days. My parents got divorced when I was at a very young age, and it's over half of marriages end in divorce, which is really tragic, but it's also something that if we realize it as just a reality to face, then we can address the issue. Now, an even greater concern is long-term care and nursing home costs. Now, it's no surprise that one of the biggest political issues really over the past decade have been the rising costs of medical care, and nursing home care really just leads the charge in that area. And so costs are constantly going up, and it's really oftentimes surprising for people to hear that the average cost of nursing home care in the Houston area, now in other areas of the country, it is way more expensive. So we can feel a little bit blessed about living in Houston. But the average cost per year in Houston is $63,000 a year for nursing home care. That works out to $5,250 a month. Now you can only imagine how quickly that can eat away at an estate plan. A nest egg that you saved your whole life for can go away just like that to the nursing homes. And so we're going to address that concern as we go on. So the crisis of the rising medical costs is not just something out there that you've heard it affected somebody. It affects almost everybody in some way or fashion. And so I used to work with a U.S. bankruptcy trustee, and I sat in some of these bankruptcy hearings because over half of all bankruptcies are due to really crushing medical costs. It's truly sad to see. I mean, people just want their families to get the care that they need, that they deserve, but the cost is so overwhelming that they ultimately end up going into bankruptcy. And that is devastating in and of itself. And then let's say over the past really 15 years, but especially over the past 10 years, there really has been a prevalency of online do-it-yourself, either free forms that you fill out for estate planning or sites like LegalZoom who help you in some ways, but are no substitution for having an estate planning attorney that knows your situation personally. And because of the prevalence of all of these poorly drafted documents where the consumer really doesn't even know what the language in the document means and how it could substantially affect their family, there have been an increasing number of lawsuits related to estate planning because these documents are so poorly drafted. And so this has become an ever increasing problem in America. Now, there's lots of issues that can be associated with poor estate planning. But typically, we run into, with our clients, so our firm's been around for 26 years now. There's a fair bit of experience in knowing what the biggest concerns of our clients are. So what we went ahead and did is summarize those concerns into a short list. And so the first priority that many of our clients want to avoid is no government involvement. Typically, and I guess unless you got strong socialist leans, you don't want the government involved in your personal affairs. It's just part of being American. And also, nobody wants to pay more taxes and fees than they would want to, or than they would need to. And that's just, again, wanting to pass on the assets that you worked hard for to your family or charity. Now, avoiding nursing home costs is another huge concern of our clients. Like I said, nursing home costs can absolutely crush a nest egg, a life savings. And so we want to provide ways to help protect that from nursing home costs. Next is, once you're gone, you're not going to be able to help protect your family members from creditors and predators. You're not going to be able to give them some good advice because, you won't be there to do so. And so we want to provide mechanisms to help protect your beneficiaries from creditors and predators in the future when you're not there to do so yourself. Next is a really big one, and this is a personal issue, which I've experienced personally also, is that whenever there is the death of a beloved family member, it can be a breaking point for a family. And so what we want to do is create planning that really brings the family together upon death or disability, because far too often family gets torn apart, and that's just really something that we want to avoid. And last but not least, in fact, probably most important, is a lot of law firms out there are going to focus on strictly how can we best administer the assets for tax efficiency and other purposes like that. We want to take a much more holistic approach to your estate planning. So not only do we want to pass on your finances in the most efficient manner possible and protective manner possible, but we also want to protect and pass on your wisdom, your values, and your life lessons, because that's really what defines a family, is the legacies of values that are passed down from generation to generation, such as hard work, stewardship, fairness, anything you can think of that gets passed on. You think about what was important to your grandparents and what's important to you. Well, that was passed down somehow or another. And so we want to provide the mechanisms also for passing down those intangible assets, which are really the most valuable thing that there is. And so now you know really the 6 major concerns that we're going to discuss today. And we're going to talk about each of them in depth. And when I'm done, I hope that you have the knowledge necessary to feel confident in your ability to discuss these issues and make decisions on your estate planning. Having said that, is knowing enough? Well, if I asked it another way, I'm just guessing that everybody on the line here is at one point or another tried to lose a couple of pounds. I mean, I've put on a good 20 pounds since this whole COVID thing has occurred. I could stand to lose another 20. So what do I need to do? Of course, we all know you have to exercise more, burn more calories, and you have to eat fewer calories, eat healthier. But how many pounds has anybody on the history of this earth ever lost just by knowing those two things. Not a pound, right? You don't lose weight by just knowing what you need to do. You have to take action. And so my goal of today is, like I said, to give you the information to make you knowledgeable, but also call you to action to do something about it. And we'll talk more about that as we go on. And so briefly, just about myself, again, I'm attorney Chris Brown, recently made partner with the firm. And well, I guess I'll just start from the beginning. So I grew up here in the Houston area, down off of just north of Clay Road and Highway 6. I'm sorry, Barker Cypress and Highway 6. And went to high school here in Houston at Cy Springs High School. And that is actually where I met a beautiful young lady who I thought was just amazing. And she became my girlfriend, and I wouldn't let go of her since. And now she is my wife. And so I'm married to my high school sweetheart. Ever since sophomore year of high school, we've been together. And I couldn't feel more blessed about that. And now the two of us, we do have a child. He is 9 years old. Well, I'll just go back a little bit. So after high school, we both attended Texas Christian University up in Fort Worth, Texas. And soon after we were both graduated, we got married. And about, let's say 10 months later, we gave birth to my son, who is now 9 years old. And during that period, after my undergraduate studies, I was working at Lockheed Martin Aeronautics. And so I worked in production control, which is really a systems-based supply chain role. It was a great experience, but I felt like I needed more. And I also wanted to move my family closer towards, the rest of my family. So it takes a tribe, right? And so we moved down to Houston in 2012. I began studying at the University of Houston Law Center, where I graduated in 2015. After really in the end of my law school experience, and for about a year and a half after law school, I worked as an estate manager where I managed assets, large assets, about $50 million worth of assets for a large estate. And, it was a great job. I was comfortable doing it. I love finances. I have a finance degree. It just wasn't personal enough for me. And so I ended up meeting with Mr. Bond and became an estate planning attorney about a year and a half ago. I couldn't say or stress enough how blessed I am to have met Mr. Bond and everybody at the law firm, because it really is, I believe, a calling for me, because on a daily basis, I get to meet with families and talk to them about what is most important to them and try to figure out how to achieve it. I can't think of a better calling. And so I truly feel blessed having this opportunity, even to speak to you guys today. It really does. It's fantastic. And so that's how I got to where I am now. Now here's a picture of my family. That's my wife, Megan, and my son, Hayden. This picture was taken about a year ago. And that is what's most important to me. And that's what's so important is, and why I love this job. And I hope it shows, because I care so much about family. And so family is important to me, and I believe family is probably important to you. And so it really brings me a lot of joy to be able to help you serve your family. Now, of course, like I said, Mr. Bond is not available to be here today. He's out in the wilderness. He's a rugged guy. He's a great guy. Well, Mr. Bond was in I'll kind of skip through it a little bit, but shoot, he spent 20 years in the Army Infantry, retired as a lieutenant colonel. He originally got his undergraduate degree from Southern Methodist University, which happens to be my alma mater's rival. And then he got a degree, a master's in accounting, and worked for Arthur Anderson until he decided to start his own law firm, which was the Bond and Brown law firm. started in 1992 and is now the Bond & Brown law firm as of several months ago. And so he is extremely accomplished, wonderful guy, and I think the best thing about Mr. Bond is that he really does care about people. He cares about me, he cares about our staff, and he cares about our clients and their families, and how these plans are going to work into the misty future. He always says that I want this to work into the misty future, that we really do have a long-term objective to make sure that whatever you put in place is going to work. And we want to be there for you because things change. We want to be there for you to help adjust to those changes. Now, if you could say the same for an online forum or LegalZoom, I'd love to hear that argument. But this is, really the best service that we provide is the personal touch, the personal appeal of making sure your plan is actually going to work and that you know what's entailed in it. So this is Mr. Bond's family. He has a beautiful family, one son, one daughter, many grandkids. I think he's got another grandkid that's not even pictured here, and his beautiful wife, Jeannie. So I kind of hinted on this just a second ago, but the most important reason why we do what we do is family. And over the years, we have literally helped thousands of families achieve their goals and protect their loved ones through effective estate planning, and then being there to administer that estate planning once a family member has passed. Now, it's not just Bob or I. Many of you have already corresponded with Mary. Mary is an amazing office manager who has really helped carry this organization forward. And she cares, and so do our legal assistants, Kathy and Stephanie. Stephanie's been here for really since the beginning of the law firm, I think 23 years now. She has so much know-how, and she really cares. She wouldn't have stuck around if she didn't care about families the same way we do. So it really is a common approach just towards genuinely caring and doing the best that we can to help service our clients. And we do feel like this is our calling. I can't think of a better calling. And so that's really what's important to us. Now, before I joined the Bond law firm, now the Bond & Brown law firm, Mr. Bond made a very wise decision, in my opinion. He joined an organization called the American Academy of Estate Planning Attorneys. Now, the American Academy is a nationally recognized organization consisting of estate planning law firms, primarily only estate planning law firms, across the nation. And what it helps us do is, it's easy for a small business to kind of get set in their ways. And the American Academy helps provide us not only with the software that we use to create our documents, but also with the best practices of any law firm in the nation. And so we try to follow those best practices every chance we get. And that's really the way that we try to make sure that we are constantly providing the best customer service that there is out there in the market. But additionally, so within the American Academy, they have a team of nationally renowned academics and professionals who have helped us create the most up-to-date documents, some of the best documents that you'll find even with the biggest law firm out there in the nation. And that's hugely important to us because not only do we have the best documents, they are constantly providing us with new insights on improvements. And so we're constantly improving our documents, making sure that we have the most up-to-date materials available for our clients. Now, before I go any further, I do have to congratulate you guys. So not only is there a tropical storm going on right now, and a pandemic, nonetheless, but you have shown up on a computer meeting to talk about death and taxes, nursing home expenses, families torn apart, and plans not working. I mean, that is pretty dire if you ask me. But I do have to congratulate you, because there's a lot of people out there that just end up procrastinating on addressing these issues. And so, fantastic job. And kind of on that note, I'd like to talk for a moment just about why people don't get their estate planning. And briefly, so there's been several recent studies done, one by AARP, another by caring.com. Both had the same results. About 60% of Americans have no estate planning. And of that 60%, half of those know that they need to get estate planning, but simply haven't gotten around to it. And there's a good reason for that. It's procrastination. And so estate planning is one of those things where you know that it is important, but on any given day, it never seems exactly urgent, right? There's always tomorrow, right? Until there isn't. And so that's really one of the biggest obstacles with people getting their estate planning taken care of is procrastination. Putting it off, thinking that it'll be done next day, next week, next month, next year. A funny story, I have lots of funny interactions with clients. I mean, that's my favorite part of the day, is getting to work with clients. So I had a couple, they were kind of debating with one another as at the end of the consultation as to whether they wanted to take action at this point in time. And his wife said, well, tell me, do you have a plan then? If you had a stroke, do you have a plan? And he said, well, I've been practicing writing with my left hand. I thought it was hilarious. You know, everybody's got their own little twist on things, but of course there's no substitution for a good estate planning, whether that be for disability or death. Remember, those are the two contingencies, disability and death. Too often people just focus on death and not the disability side of things. And I'm going off on a bit of a tangent here, but as our nation's medical capabilities increase further and further, people are tending to live longer, but still Americans are suffering the same amount of mental disabilities such as Alzheimer's and dementia. And so there is a greater and greater likelihood that at some point in your life, you will become disabled in your final years. And so that's absolutely something that we want to address and be able to prepare for. Now, the second reason, on top of procrastination, why people don't get to actually implementing their estate plan is a lack of knowledge. And you can kind of think about it, you know, let's say you're going to go buy a car. What do? Well, you go online, you look at Kelley Blue Book, you look at competing offers, seeing what the best value is out there until you figure out which car you want to get, from which dealership, what color, you know, doesn't matter how detailed you get on it. Well, estate planning is 10 times as complicated. I mean, I wouldn't have a degree and a profession in estate planning if it wasn't a complete set of knowledge already. And so just getting online and trying to learn what you think you need to learn about estate planning, quite simply isn't going to do it. Unfortunately, I wish that were the case, because I want more Americans to be protected. So one thing I've got to say is that many individuals who have gotten over the procrastination stage and say, all right, it's time to take action, let me learn what I need to do, they get overwhelmed. You can imagine going online and learning that there's, you know, 10 different answers for the same question. You just got to know the particulars of exactly which one is correct. And with that being overwhelmed, people just give up, unfortunately. And so today, what I want to do is provide you with the applicable know-how towards what we're discussing and what's, I think, is most important for you to know within our time limit, But like I said, we're also going to discuss a call to action so that we deal with the knowledge issue and the procrastination issue. Now, there's lots of different planning options out there for estate planning. And the most common option that there is, like I said earlier, 60% of people don't have any estate plan. The most common option is no plan at all. And typically that's called dying intestate. Now, you could also be disabled and not having planning, but dying intestate is dying without any estate plan. And that is the most common plan. And in such a scenario, essentially what happens is the court is going to take control. And there are certain rules set by the legislature that determine where those assets go. The court can determine who administers those assets. However, whoever administers it, the court's going to be right over their shoulder the whole time. They're going to have a difficult go of it, and potentially family members will. Just for a little side cue here, a probate in our office costs twice as much without planning if someone dies intestate, because the court is so involved. And anytime the court's involved, it costs time and it costs money. Now, the second planning option available is, of course, a will. Now, that's your most traditional planning. If you hear me talk about traditional planning in the presentation, it has to do with will-based planning, because that is what most people think of. Now, a will is a useful document to have. Like I said, it's twice as expensive to do a probate without a will than it is with one. But a will is limited, and I would like for you to hopefully look at a will as really just a safety net. A will is there to catch anything falling, which would be subject to probate. There's a lot of assets out there that are not probate assets, and we'll talk a little bit more about that in a minute. One more thing to know about will-based planning is a will is only effective upon death. Before you're deceased, the will has no impact on your day-to-day life. And that is also true if you're disabled. And as such, a will is not a disability planning document. Now, if we do wills for somebody, we provide disability documents to accompany them. However, they differ in degree as opposed to our next option, which is a living trust. Now, a living trust is, it's very popular, especially in certain parts of the country, which have extremely high probate costs. Now, Texas isn't as bad, but there are huge benefits to having a living trust. So what a living trust is really a much more comprehensive version of a will. It helps administer your assets, distribute the assets, and can be done so in a much more controlled manner and with far more protections than a will would provide. Additionally, a living trust does not require a probate, and that's a big deal. And we'll talk a little bit more about that, but a lot of people, once they get done with this presentation, do not want to deal with probate, and I don't blame them. But there's lots of options out there for living trusts. I mean, there's door-to-door annuity salesmen who are selling living trusts that are just bare bones, fill in the blank documents. You know, I would recommend a will over one of those. And so there's lots of options out there with living trust, which is what brings me to my last point, which is what we do here at the Bond & Brown Law Firm, is legacy wealth planning. Now, legacy wealth planning incorporates the living trust, but it uses a holistic approach. Like I said earlier, we don't just focus on finances. We really want to know what's important to you, what's important to your family, and what are the family dynamics? How is all this going to work? And how can we pass on not just finances, but also values, memories, stories, all of those things. And so that is what consists of our legacy wealth planning, so that we're able to pass on values and legacy, hopefully for multiple generations to come. And so that's what our focus is. And we'll address that more as well. So what I promised to cover with you today, and I'll probably pick up the pace just slightly, is why traditional planning has failed most Americans. Remember, traditional planning is just your will-based planning. Why most estate plans don't work, the benefits of legacy wealth planning. The one big part is just identifying the critical parts of estate planning, because I want you guys to have that knowledge to work off of. And so there's a lot of working parts to estate planning. So I want you guys to be knowledgeable on that. And then lastly, I'm going to work through showing you, at least partially, how to create a lasting legacy for your family that represents not just a passing of your assets, but also of your wisdom and values. That's what we specialize in. And then, of course, at the end, we'll have time for questions and answers. All right, are you guys ready for an epiphany? Well, what's an epiphany, first off, right? An epiphany is that aha moment when it all finally comes together and you realize that's what I need to do. Well, I can't guarantee that everybody here will have an epiphany during this presentation, but I sure hope that you will, because the materials that we're going to present are vitally important. I mean, just think of everything you work for. I can't think of much else that would be more important than your estate planning. And if you've worked your whole lives building something, then you want to make sure that you can leave it in the manner in which you wish to do so. Now, with that epiphany is not just the know-how, like I said, it is the epiphany of, I can't procrastinate on this anymore. It is an important issue that needs to be dealt with right now. And so to begin, really what we've learned is that the best way of presenting these materials is with an example. And so what I'd like to do is introduce you guys to the Joneses family. And so Bill and Mary have been long time married. And just to begin, Bill he was a surveyor for a big pipeline company for many years. He just retired, let's say a week ago. And Mary was a school teacher. She worked as a school teacher for many years, and then as her children were born and became really toddlers, she ended up being a homemaker and full-time at home to take care of the children. Now, Bill and Mary don't consider themselves to be wealthy, but they are, well taken care of. They've done well for themselves. So you say maybe $1 million. Now they have 2 children, John and Susan. They were both raised in the same household under the same roof. They were given the same lessons, taught the same values, but just like I've seen out there with real life families, the kids did not end up in the same disposition. So you got Susan, who's the daughter, who, let's see, in high school, she was in the drill team. When she graduated, she went to Baylor, got a master's in accounting, was successful, became married after getting her degree, and has 2 children of her own. And now those grandkids are the light of Bill and Mary's eye. They just love them. Now, John, on the other hand, you can kind of tell just by the picture there that John did not take the same path. He, in high school, always kind of ran with the wrong crowd. In college, he started drinking heavily and partaking in drug activity, and ended up not finishing college, and ever since has been unable to hold down a relationship or a job. Also, John has had a lot of difficulties paying off his dues. So even with the IRS, he owes a substantial amount. So 2 kids, same scenarios, but different results. All right, now keeping Bill and Mary in mind, the first mistake I want to talk about today is that there are people set up plannings where there's no protection to pass on your hard-earned wealth without government or court involvement or interference. And like I said, unless you got some socialist leanings, most people do not want the government involved in their day-to-day affairs, especially if they're passed and the government's just wholly making the decisions for them. Now, there's two different scenarios where the government could be involved. And like I said, there's two contingencies, the first being disability and the second being death. So there's what is called living probate. That is basically the probate that assigns a guardian during disability. And then you have your death probate, which is in charge of administering assets after the death of an individual into the name of the correct beneficiaries. And so starting with the living probate to appoint guardianship, I'll just say more than anything, this is such an easily avoided issue. But when it comes up, it is so difficult for families and so costly and unnecessarily. I mean, it serves a role. So the role of living probate is to assign a guardian, someone to take care of the disabled individual who can't take care of themselves. Now, that, socially speaking, that's a good thing. We want our impaired individuals to be looked after so they're not taken advantage of. However, in most instances, it's just a family member, a loved one who truly cares about that disabled individual that wants to take care of them. I mean, that makes sense, right? However, because of a lack of proper documentation, whether that be a power of attorney or a living trust, there have to be hoops that are jumped through to take care of the disabled individual. And so with a living probate, first of all, if the person is competent, it's humiliating for them. They are basically drugged into court and told that they are incompetent. Next, probably the biggest issue is the court is in control. It doesn't matter who the disabled individual wants to be their guardian or would have wanted to be their guardian. It's just who the court appoints. The court is the one who decides. Next, it's time consuming. So you can imagine, this is probably I think a living probate is worse than a death probate because it is time consuming. And the reason for that is a disabled individual can remain disabled for many years, a decade at least. And so over that time period, the family members who are taking care of the disabled individual are having to work through the court system to just take care of their loved one. All of that time and effort costs money, whether it be court fees, attorney fees, what have you. It's expensive and it's time consuming. Again, anytime you gotta go to court, it's expensive and time consuming. So we wanna avoid that. Let's see. Now your next option, or difficulty that you would face with government interference is the death probate. So this is the probate that would be faced if a loved one passed away, or if you were to pass away that a loved one would have to deal with. And so again, it can be expensive. Anytime you go to court, it's expensive and it's time consuming. We want to avoid that. Some of the bigger issues having to do with probate is that a probate is a public court hearing. So whatever is presented in your probate, if you have to go to probate, is public information. So for starters, there is an inventory of assets. Whatever you own is going to be inventoried and is now public information. Let's say this is $10 million. Maybe not, but let's just say it is. Now, what is also public information is who the beneficiaries are. So now somebody out there can look and see that your son or your daughter is set to inherit X amount of money, and that is where the creditors emerge. It's all public information. Now, one more difficulty of a probate is that if you own assets, particularly real assets, such as a vacation home in another state, well, a probate is effective in its own jurisdiction. If you own real assets outside of the state, now I'm not talking about accounts, just more like real property, then there's likely going to need to be a probate in that jurisdiction, and if not a full probate, at least some version of it. And so sometimes we do that for clients who have vacation homes in Texas, and sometimes we have attorneys in other states do it for our clients who have out-of-state assets. Either way, if you could avoid a probate in the first place, none of this would be an issue. And we're going to talk about how to achieve that. All right, big issue. Planning mistake number two is no nursing home protection. Like I said earlier, a will is your traditional planning. A will has nothing to do with protecting against nursing home costs, which can destroy an entire life savings. In fact, a lot of times, ironically, the recipients of nursing home care end up not having any estate to pass on because they spent it all paying for their nursing home care and their long-term care, when if they had planned in advance for that issue, even once they got into a nursing home, we could help protect thousands, hundreds of thousands in some cases of dollars for the family to pass on, as opposed to all of that money just going to the nursing home. So just a little bit on this subject is that, first of all, your do-it-yourself plan that you get online, that you can count that out. That's definitely not going to have any sort of nursing home protection. And we talked about the overall cost. It's about $63,000 a year for nursing home care. And I'm going to hit on this a little bit more because there are really several ways in which you can pay for your nursing home care. First of all, you can use your own money, of course. You can pay out of pocket. And I promise you, that is what the nursing home would most prefer. And I'm not by any means bad-mouthing nursing homes because they provide an essential service. In fact, they refer a lot of clients to us. But I will just say that nursing homes get paid more when you pay out of pocket than they would from, let's say, a Medicaid bed. And so they are incentivized for you to pay out of pocket as long as possible until you're out of money, and then they'll suggest the Medicaid option. Well, if you can qualify for Medicaid sooner, then I would absolutely advise it. That way you don't spend down all of that money. But Medicaid is not the only option. Option number two is buy long-term care insurance. And this can be a fantastic option, but you have to meet the right criteria. So as you get older, the premiums on that long-term care insurance really become too expensive to be practical. So, if you're a younger couple, then long-term care insurance may seem practical, especially, let's say, if it were life insurance with a long-term care rider, where even if it was not used, the family would get some of the money back. And so as long as the premiums are reasonable, then long-term care insurance is a great idea. And if that's something that you want to consider, I have a great advisor who does a lot of work in that area. Now, option number three is applying for limited Medicare benefits. Now, let me tell you, nursing home costs are covered by Medicare just enough to confuse people. And so what happens is with Medicare, you are often afforded a period of rehabilitation. And oftentimes that rehabilitation is in a nursing home. Now that is for a limited duration, really what the doctor prescribes, almost standard, it's less than 100 days. But that's enough to confuse people because they think Medicare has taken care of them. Well, that is not the case. And so what we want to look at is the Medicaid option. And so Medicaid is the program that in America pays for really over half of all costs associated with nursing home care in this country. And so it is a very broad program, an inexpensive program, but can be very helpful to families. And so we're going to talk more as we go along about how you can qualify for Medicaid and really save your nest egg for your family to inherit. Now, I'll probably get into this more in a minute, but if you just baseline looked at the rules to Medicaid, you have to be flat broke to qualify. I mean, you can't have more than $2,000 in assets, countable assets. $2,000, that's getting pretty broke. So what we do is we look at the entire situation and we analyze the finances and the personal aspects of things. And many times the rules are complex and very fact specific. But what that means is that with that complexity and fact specificness, we're oftentimes able to qualify individuals who, are middle-class families with $500,000 or so. And so there are ways of qualifying. We just have to go through the process of analyzing the situation and creating a plan and executing on that plan. And so Medicaid is not out of the option for a lot of middle-class families who think that they simply don't have access to that program. Now, lastly is the Veterans Aid and Attendance. This is through the VA, and it's available to veterans and their spouses who had at least an honorable discharge and who served during a wartime period. Now, this is a great service for individuals who need a little bit of extra help, especially if they're receiving at-home care. And the reason why I say that, as opposed to the Medicaid program, is that the VA Aid and Attendance doesn't provide enough to cover nursing home costs. It does provide enough to help out with some at-home costs. So if you've got somebody coming in for 20 hours a week, it can help pay for those expenses. But for full-on nursing home care, VA just is not quite enough. Now, if you need any assistance, or we can answer questions about VA Aid and Attendance. However, it is the VA office who will actually get you qualified and help you apply for those programs. But we try to encourage people to seek that out whenever they can, because it is a wonderful resource. All right, so a little bit more about Medicaid. I think I already talked about a lot of this, but it is a joint state and federal program, and it does pay for most of the long-term care expenses here in America. Like I said, it says that you have to be basically broke to be able to qualify, but through our efforts, we are able to help families qualify much sooner than that and protect a lot of their assets so they can pass it on to the next generation. All right, and continuing with a little bit of our storyline here, we haven't talked too much about Bill and Mary yet, but before we go any further, what I'd like to do is also introduce you guys to Ralph and Ruth. And so you can see Ralph and Ruth over there on the left, and they have two children, Rachel and Ryan. And of course, don't forget about Rover. We all love our dogs. And so the story with Ralph and Ruth is that, well, their kids are the same age as Bill and Mary's. They moved into the neighborhood about the same time Bill and Mary did. So they've known each other for a good number of years. The kids all played together. They're just neighborhood close relationships. However, the story for Ralph and Ruth is a little more dire. So I don't know if any of you guys on the call right now have ever seen this or dealt with this, but Ruth was diagnosed with early onset dementia or Alzheimer's. If you know anybody who's ever dealt with that, it is really tragic. Unlike later age Alzheimer's, early onset dementia or Alzheimer's really takes a toll quickly. And it really is sad because they're younger. And in fact, it's the most dangerous thing you can think of in estate planning because the person looks young, they look healthy, they look capable, but they really don't have the right minds to them. And so when they go into a bank or they go into some sort of transaction, to enter a transaction, the other party really doesn't know the whole story of what's going on. And so it's easier for things to happen that can really devastate the family. Now, Ruth's story is that she was admitted to a local nursing home. She stayed there for 37 months. Now, Ralph spent everything he had. He loved Ruth so much. He spent all of their savings on her care. And so basically their nest egg was gone at that point. Now, it was for a good cause. He wanted Ruth to be comfortable. He wanted to be safe and taken care of. That is all reasonable expectations of a loving husband. However, due to all of this, they had to declare bankruptcy. Now, Ruth was disabled at this point, so really it was Ralph declaring bankruptcy on behalf of both of them. They lost everything financially. All that Ralph had at that point, and this is not a stretch of the imagination, this is somewhat common. Like I said, over half of bankruptcies are due to medical costs. All he has now is his Social Security income. He has nothing to leave to the kids to pass on. He really has no ability to take care of himself if an emergency struck him. And there's also an issue where if Ralph ever needed assistance, there's a concern that the state would be able to seize his home after providing Medicaid assistance. All right. That's one big issue with Medicaid planning is there's a huge fear, because it's true. If you qualify for Medicaid, the state has the right to come back and collect on the amount they spent on your care from your estate. So if you own a home, they do have a right to come and take a claim of that home for that amount that they provided. Now, what I want to impart on you is that there's no reason to be afraid about that. And it's a deterrent to a lot of people when it shouldn't be, because through a couple of very simple instruments, we can eliminate the state's ability to recover that asset. It's called Medicaid estate recovery. And we can avoid Medicaid estate recovery, again, very simply, if the individual just comes and pays us a visit. All right, so we talked pretty extensively about the Medicaid planning issue because it is extremely important. Now, also extremely complicated. Now, planning mistake number 3 is, well, there's no remarriage protection with traditional estate planning. So before I get into the slide, let's just imagine the scenario. Husband passes away and leaves everything to his wife. In fact, I'm going to use my own personals. I'm 35 years old, and so is my wife. If I passed away tomorrow and left everything to my wife without the trust planning I had in place, it would all go to her. And if she got remarried, then really there is a strong chance that that new husband, and I would hope that she does, I hope she finds happiness. All of those assets that are hers once she gets married start to become commingled as community property. And so it's not just the new husband and I want my assets to go to my wife's benefit and then my son, not to this other stranger I don't know. I've got to worry about that now if I just have basic will planning. And it's not just that new husband, it's also their children who could make a claim to part of the estate. And so remarriage protection is a huge deal. So I gave the example of myself at 35. Late life, late season relationships, whether it be marriage or more likely cohabitation, is a greater likelihood than a lot of people would like to believe. Ultimately, I could use my dad for an example. He got married pretty quickly after the death of my stepmother. But typically what ends up happening is, there's a period of grieving, typically about 9 months. And then if you can get past that point, the surviving spouse, well, they have to deal with issues of loneliness and a desire for relationships and belonging. And so it's just a matter of nature. No matter how much you think it wouldn't be your case, people are always going to seek out that sort of deep connection at whatever age. And so remarriage protection is extremely important, no matter what age you're at. And so with your basic will planning, there's no remarriage protection. Quite simply, it all goes to your spouse, and then if your spouse gets remarried, well, then it's fair game. Yeah, that's how a lot of in fact, you probably heard of the story where grandma died, grandpa got remarried to someone 10, 15 years younger, and of course the family farm ended up going a whole different direction out of the family. It's not that uncommon. Your traditional estate planning also won't keep your assets from going to that individual's children. And so what we always try to focus on is, as long as the family, that's their objective, we want to keep the money in the bloodline, in that original family structure, to be passed down from generation to generation, but within that lineage. And here is a huge one. So I mentioned earlier that divorce is a huge, just problem that has plagued Americans for a couple of decades now. What that means, though, and I've experienced this myself, is that there are a lot of people who have blended families. I grew up as part of a blended family. I was actually raised by my grandparents because of that issue. But blended families where there are children outside the marriage, absolutely require remarriage protection. Because if not, your kids can get cut out just like that if you're the first to pass. It really is a huge concern. And in fact, anybody with a blended family, I'll tell you now, trust-based planning is the way to go. I'll talk more about why that is, but I just want to make that blanket statement. And I would always make that blanket statement with confidence. So one more issue, to discuss about remarriage protection is that our trust language, not only does it protect the deceased spouse's portion of the assets to make sure that it goes down the correct path while still taking care of the surviving spouse, there's also language that requires that if the surviving spouse is to get remarried or cohabitate, that they get a prenuptial agreement in advance. And if they don't, there are consequences. Now, this is not to punish the surviving spouse. It's merely to actually make it easy for them when they get remarried or cohabitate. It's an awkward thing, right? Asking for a prenuptial agreement. And so by having this trust language in place, it puts the surviving spouse in a position where they can say, I'm sorry, I have to get this prenuptial agreement. And if I don't, then I lose out on all of this money that's to my benefit. So it really does make it's a benefit to the surviving spouse, not a hindrance. But it's extremely important to making sure that everything actually flows the way it should. All right, so we didn't really talk about it, but gosh, Bill went through a stroke and had a period of disability, and then he eventually passed away. Now, the average surviving life expectancy of the surviving spouse, at least here in America, is 7 years. More typically, it's a little bit strange, but if you can make it past the first 9 months of that deep grieving period, then there's a pretty substantial survival rate after that. It's that first 9 months that are really tough on the surviving spouse. Now, good news for Mary, she actually outlived that 7 years. And so what that means is this remarriage protection is pretty important, right? Because there's at least 7 years there plus where there's opportunity for Mary to find some other relationship which could legally be dangerous to her estate. Okay, moving on real quickly to mistake number 4, which is, like I said, once you're gone, or your kids are going to be on their own. And with the traditional planning, will-based planning, there's no divorce, creditor, or lawsuit protection for the beneficiaries or their heirs. And so again, we're back to the issue of divorce. If you got 2 kids, the likelihood is that one of them is going to get divorced at some point. That's just the statistical matter. As much as nobody wants to think of that being the case for their own children and the heartache that's associated with that. But kids, they will get divorced, and assets do end up going outside the marriage because of it. If you left everything to your son, or your daughter and they got divorced, if whatever amount of that property had been commingled with basically the community property, typically what ends up happening. So an inheritance is separate property. But let's say it's put into an account with both individuals on it. Well, eventually it's become so commingled that you really can't trace back where the separate property came from. And if you were to, it would cost so much in attorney fees that it just wasn't worth it. So ultimately what ends up happening typically is settlement agreements are reached and the divorcing spouse, who is not your son or daughter, ends up walking away with at least a portion of the inheritance that you left for your child, which is pretty heartbreaking if you were there to be heartbroken. Now, the other difficulty is it's not just divorce. There's also creditors and predators out there. I mentioned the risk of predators having to do with probate when you put your public information out there. Well, there's always going to be opportunists who are looking to take advantage of the beneficiaries of your estate, whether that be through relationships or potentially romantic relationships, but also, there's always going to be somebody out there with a get-rich-quick scheme that is going to look to take advantage of your child or your beneficiary. And so we want to be able to protect those assets even when you're not here to protect it yourself. Another issue is, nobody can ever predict this, but lawsuits and even creditors can be an issue. If you have the proper estate planning, not just will-based planning, but really comprehensive estate planning, you can avoid the threat of your inheritance that you leave being ever affected by your child's lawsuit or debts. That can be huge. And let's see, I'll get to it in a second, but I'll explain why that is. Lastly, and this is such a huge one, when you leave an inheritance, and I'll talk more on the next slide about this, there is a traditional pattern. Divide, dump, and dissipate. You divide it between the kids, you dump it on their laps, and then you watch it go away. There's a much better way. So far too often the kids just are not financially mature enough to have a lump sum of money dumped in their laps. Either they are already in debt, or they have expensive tastes, or they have a spouse that has an expensive taste. Whatever it may be, they just may not be financially mature enough to treat your money that you're gifting them the same way they would have treated it if they had earned it themselves. That's just kind of a psychological issue. It's easier to spend somebody else's money than it is your own. So on that issue of financial maturity, we really discussed it, but if you look up the average life expectancy of an estate that's left for beneficiaries, it's not that long. It's less than a year. People just tend to spend their inheritance as if it were a windfall. And that is really not, I hope that's not what you want your children to achieve. Hopefully it's something that can last with them throughout their lives and be as a supplemental benefit. And then be there for your grandchildren and your great-grandchildren. Now, if it all gets spent recklessly, even if they think they're investing themselves wisely on risky investments like, I don't know, Virgin Galactic or something, some crazy stock idea, it's just not going to maintain over the long term. Now, you guys remember, I talked about Susan earlier. That's Bill and Mary's daughter. So Susan was the one who was on drill team. She went to Baylor, got a CPA degree, had 2 lovely kids. She did basically everything right through life, except for one thing. And that was marrying the guy that you see on the screen right now, and that's Jason. That was her biggest mistake. Jason, as you can tell, well, he always had a drinking problem, never really held down a job. But Susan loved him, and he was the father of Bill and Mary's grandkids, so they put up with him because, well, they love those grandkids and didn't want to risk anything, getting in the way of them having time with those grandkids. Now, if it were up to Bill and Mary, Susan would have divorced them many years ago. But Susan was still married to Jason when Bill and Mary both passed away. So Susan inherited Bill and Mary's estate outright into her own name. Well, after a couple of years after Bill and Mary's death, Susan finally got wise and she divorced Jason. Now, what do you think happened to that inheritance? After a couple of years of them being married, it had been in a joint account, even if it were in a separate account, capital gains on separate assets are community property. It's real easy for assets to become commingled. Well, if you haven't guessed it, there's a good chance that Jason is going to walk away with up to half of the inheritance that they left for Susan. Now, Bill and Mary would have rolled over in their grave if they knew that the son-in-law that they never liked in the first place, who they only put up with because he was the father of their grandchildren, is now going to be out of the picture, but with a quarter of their inheritance their nest egg that they left behind. I mean, that is something that we absolutely want to avoid. And that is something that we accomplish with our legacy estate planning. Now, here's another big issue. You remember John, he's Susan's brother. He's the son of Bill and Mary. He never ran in the right crowd, just never seemed to get things straight. Well, he's going to inherit the other half of the estate, outright into his name. Now, what do you think the first thing that John did when he inherited that money? And let's say it was $350,000. I'll give you a hint. It's in the background there. He bought a shiny red sports car. It's almost in his blood. And so, well, you can imagine John is a walking liability factor, and he is so proud of that car. He, takes on any opportunity he can to race anybody who's willing to challenge him. So what do you think happens to John next? Well, I of course can't hear all of you right now, but you're probably going to say that he got in an accident, right? Well, sure enough, I'm sure he will sooner or later. And, the roosters will come home at that point. But what's more of a problem for John immediately is I had mentioned earlier when I introduced John that he had, let's just say, a casual behavior towards paying his income taxes. He had IRS issues. If John inherits that money outright and he already has a debt to the IRS, as soon as that money gets into John's bank account, the IRS is the most powerful agent there is out there. They're going to reach right into his bank account and pull it out. And that is just going to be another disappointment in John's life, another failure. And it sure is not going to be what Bill and Mary saved their hard-earned money over, was to pay off John's IRS debt. Now, if the money were kept in trust, that money would never be exposed to that liability. Now, let's imagine your original assumption came true and John got into a car accident racing that fancy red sports car back there. The same is true. If the money is held appropriately in trust, not the way, just will-based planning, but through legacy wealth planning, then that money would never be exposed to that sort of lawsuit. It's protected. And we'll talk a little bit more about that as we go on, but I just want you to know that there's some pretty substantial risks here if you have a son like John, or even a son-in-law like Jason that we just discussed a second ago. There are risks at hand that your traditional estate planning simply isn't going to address. I really kind of talked about lawsuit expenses. So it's not just the son and daughter, not the beneficiaries who are subject to lawsuits. It could be the surviving spouse. And so we're also able to protect at least half of the estate if the surviving spouse were to, let's say, be reaching down for their coffee and get into a rear end accident with a school bus where, there's substantial liability. I'd like to imagine some less dramatic scenario, but, if there is a substantial liability due to some sort of accident or some sort of creditor, then we can protect not just the children, but also the surviving spouse from losing everything. Okay, planning mistake number 5, and that is not having the proper protections and planning for your IRA or 401k, basically your retirement plan. First of all, I'll just say as a blanket statement, too many people work off of wishful thinking when it comes to their retirement planning. So if you remember when you set up your 401k or IRA or whatever retirement plan it is, it might be a 403b if you're a teacher, you designate beneficiaries who are going to receive the benefit of that account if you were to become deceased. A lot of times those get set up 20, 30 years ago and never looked over again. Even if, let's say you got divorced or remarried, or if you had more children, there's all sorts of issues. It's something that I really want to stress to you that it's worth reviewing every couple of years just to make sure. Because typically a retirement plan is, besides the family home, typically either the most valuable asset or the second most valuable asset. And although it is not a probate asset per se, we definitely want to make sure that it is going to go where it's supposed to go and work with the plan overall. And that's what I was really talking about, a holistic approach. We want to look at everything and make sure that everything flows as it should, and that the assets and the family dynamics are all in unison. Now, there are a lot of missed opportunities having to do with retirement accounts, and really what I mean by that is there is a lot of opportunity to keep the assets in that IRA wrapper, that 401k wrapper, so that it is tax deferred. And we want to keep that tax deferral for as long as possible to maximize the benefit of it. Now, here in Texas, there is a natural creditor protection when it comes to your retirement accounts. Texas is kind of unique in that aspect. So if you were to get in that accident, well, your IRA is not going to be exposed. Your 401k is not going to be exposed to that liability. However, so that's a huge benefit here in Texas. Now, I can't say that that'll last forever, and it's definitely not true in other states. So you have to look at your own personal circumstances. But more importantly, what we want to make sure is that eventually those assets are going to have to come out either to you once you get to 72 years old now, after the Secure Act was passed last year, or it's going to go to your children as an inherited IRA, or your spouse as a rollover IRA. Whenever those payments come out, we want to make sure that they come out in the most protected manner possible. That way the money is never exposed to really all of the dangers that we've discussed thus far, such as disability, remarriage, lawsuits, and creditors. We want to keep the distributions flowing in trusts so that everything is always protected. All right, we talked a little bit about it already, but mistake number 6, and I'll go through this quickly, is just that there's a lot of options out there for cheap documents or free documents. We typically call them our bare bones documents, and there's a lot of attorneys out there that actually practice in contested probates and protested estate resolution. That's not us. We don't want to deal with the contest. We are all about getting the planning right the first time and then just administering the estate based on that planning once it's already been set up. But there's so many people out there that have these bare bones documents that they really didn't understand in the first place and have provisions that just don't protect what they want to protect and don't achieve what they want to achieve. And so that brings about lawsuits. So a lot of attorneys actually like these sort of documents. But more particularly, I want to talk about bare bones trusts, because they are out there, where it's basically a fill-in-the-blank trust. Now, we're going to talk in a minute about how trusts work, because it is the best solution. But I will say that the most common errors having to do with trust-based planning are not having to do with the actual drafting of the document itself. I mean, that is often a big issue, but more so it is having to do with a lack of funding, of proper funding into the trust. And I'll tell you a bit more about what that means in a minute. But as you can tell, just your basic plan, it doesn't have protections for all of the issues that we've discussed thus far. And funding the trust is a very important deal. I'll explain that in a second. Actually, you know what? I'm going to go ahead and explain it now. So what I mean by funding is, because this is a big deal and I really do want you to have a firm grasp on it. Whenever you set up a trust, it's essentially a contract with yourself. So a revocable living trust is one in which you are the trustor, you created the trust, you are the trustee, you have control of the trust, well, you got the checkbook, and you are also the beneficiary of the trust. You fill all three roles, and it's basically business as usual for you. However, a trust only controls assets that are in the name of the trust. So let's say you've got two real properties, both of them here in Texas, just for simplicity's sake, one in Austin, one here in Houston. Your Houston house, you retitle the deed into the name of the trust. With the Austin house, well, you just neglect to do so, which happens a lot of times when there's no law firm to help you along with the process. Now, the trust and the language in the trust is only going to control that Houston house that was titled to the trust. The Austin house that was not titled to the trust, it might as well have been as if the trust never existed in the first place, because the trust only controls assets titled in its name. And that's why funding assets, so whatever you have out there, whether it be your accounts, your real assets, your tangible personal property, we want to assign it all to the trust. That way the trust is controlling. Now, I guarantee you, if you went online, even on LegalZoom, it's probably one of your better options online, they are not going to help you with that. And if they do, it's going to be subpar at best. Now, that is an area where I mentioned it earlier, we are very determined to make sure that whatever planning you set up with us is going to work. Well, it ain't going to work if it's not properly funded. And so that's one of the big reasons why we take a lot of efforts making sure, as much as we can, that your assets are properly titled in the name of the trust. Or if, for example, your retirement accounts, which aren't going to be in the trust, that they flow into the trust at the appropriate time. And so we want everything to work together. And that's really one of the biggest benefits of having a law firm help you with your planning. All right, planning mistake number 7. This is the last one here. So no legacy protection. Like I said earlier, most estate planning law firms are not going to focus a whole heck of a lot on anything other than your finances. I tell you now, in my consultations, finances are, I probably talk for 30 minutes before I talk about finances. I want to know about you, your family situation, you know, what's important to you, what are your values, what are some of the things you hold dearest, and then we work from there. Then we talk about finances. And so on top of that, we want to be able to provide a manner in which you can leave your stories, your legacies, your memories to the next generation. Because if you think about it, well, let's say your husband and wife, well, your spouse probably knows a good bit about, you know, a lot of the stories from when you were younger, before your kids were around, or maybe when they were real young. But how many of those stories do your kids really know? And if so, how accurately do they know it? Do they really know the truth, or just some sunny version that you told them when they were young? You know, it's not all good. There's negative stories to tell as well that really are important as well. And then you go another generation or another generation. Eventually those stories and those valuable, incredibly valuable, almost irreplaceable life lessons have disappeared into, the lack of being remembered. And so this is a very big deal. And what we want to do is provide you with a legacy plan that helps you, jot down your family folklore, your words of wisdom, your memories, your stories that really developed you into the person that you are, both as an individual and as a couple, as a married couple. And so it really is a big deal that all of those things get documented, because if they don't, this is a big area of procrastination, honestly, probably even bigger than estate planning. A lot of people get their estate planning done and they say, I'll get to this next. Well, this is important. I think it should all be done together. All right, so if we want to summarize real quick, we went through really a pretty ineffective traditional estate plan. So I know it skipped around a bit because it was all condensed for the Zoom presentation purposes. But let's say all that happened to Bill and Mary. Well, first of all, Bill and Mary they had to go to probate, because it was just a will-based plan. If there's a will, it almost guarantees you go into probate. They had to, in the case of Ralph and Ruth, they had to suffer the cost of nursing home care, which put them into bankruptcy. There was no remarriage protection for if Mary, so in the more extensive storyline, Mary and Ralph comes over and he starts consoling Mary, and they go out to dinner, they go out to see a movie eventually, and then they're cohabitating. And there's a risk that everything that Bill saved for his kids is going to get lost to Ralph. So there was no remarriage protection. Additionally, there was no lawsuit or creditor protections. Really just nothing to protect the kids at all, especially John, who is already in debt with the IRS. There was no retirement plan protection, so they were just going off of wishful thinking, and whatever was distributed as a required minimum distribution would have gone to the kids outright and been exposed to liability. Next, if they had had a bare bones plan, we discussed a lot of the concerns about that. Even if you have a bare bones living trust, there is so much opportunity for it to fail that you're probably better off just not having it all. And lastly, there was no way in which they could pass along their wisdom, their values, and the family stories that really made them who they are, that were perhaps even passed down from their parents, but are hugely important to maintaining solidarity of the family generation through generation. So as you can tell, Bill and Mary, they thought they were doing pretty good, I imagine, by setting up a basic will. They thought, hey, we've got our estate planning done. That was something we wanted to do once we got retired. Unfortunately, they did not go far enough, and these that you see on the screen right now, these are the consequences of it. And so we want to talk about, a living trust and legacy wealth planning, and how you can avoid a lot of these difficulties that are inherent with traditional estate planning. So this is a big deal here is, we've talked a lot about the technicalities, and those technicalities are important to know because it's important that you know what opportunities are out there and what dangers exist. But on a broader scale, in a more introspective scale, you really have to ask yourself, how will I be remembered? What will I be remembered for? And a lot of that has to do with what will you leave behind. And I'm not talking about money. I'm talking about relationships. Like I said in the beginning, we want family to come together upon our passing or disability, because it is a stressful time for the family. A lot of times, and I see it far too often, there are family disputes. There are things that happened 20 years ago that bubble up to the surface when the stress is applied, let's say between siblings. They might have fought about something when they were teenagers, and now it's a forefront issue when it really doesn't have anything to do with the situation at hand. So there are a lot of fights that do occur when there is improper estate planning. And you probably want to be remembered for having taken the steps to bring everybody together, as opposed to how in the world did they leave us with this mess? Now, what that means is that you want to provide planning that addresses not just the assets you leave behind, but the family structure that you leave behind, and have them both work in unison together. And really, that is the why, as why it's important to do these things. I mean, from the most basic level, I'll tell you, this is not about you. You're going to be either incapacitated or you are dead. And that is harsh, but that's true. This is about your family. You're not doing this for you. You're doing it for your spouse who survived you, or you're doing it for your children who survived you. This is about them, not you. And so that is the why of why it is important to take action now. Now that's the why for you guys, as far as I see it. Now, of course, there could be more detail than that. Now I want to talk to you for a second about why we do what we do. And I'll just start with the what. So what we do is we offer extensive estate planning and comprehensive estate planning for individuals, for families, for anybody who needs it, that is customized to their particular desires, their hopes, their dreams, also their fears and concerns, and their own personal situation. So that is what we do. And we also administer estates, either through probate or trust administration, once a loved one has passed. And then lastly, what we do is Medicaid estate planning, so that we can help family members get qualified for Medicaid nursing home care when they wouldn't be able to qualify otherwise. Now, how do we do that? We do that through exercising best practices as learned through the American Academy of Estate Planning Attorneys. Also, just through our, I think our desire to serve families is a big how. I mean, that is one of the biggest hows that we have. That's what drives us every day. And then lastly, just continued education. We want to be at the top of our game and provide the best quality and customized customer service that we possibly can, because that is the value that we offer. Now, why do we do it? Well, the answer is simple, and I could show you in that slide earlier. It's our pictures of our family. We love our families and know how much you love your families. And that is what all of this is all about, is family. And it's important to us. And our general statement, in fact, our motto is that we want to make what's important to you important to us. And that's our goal. All right, so really from this point, I've given you guys a lot of information, and I'll probably be a little more brief here, but it's not just about the information, it's about taking action. So what do we need to do now? So what we need to do, you need to probably think about these issues. What do you need to do? How do you make it happen? When should you get started? Well, that's right now. And what's the investment to do it right? So let's talk about each of these real quick. So first of all, the legacy wealth planning documents. I've talked about the legacy wealth planning multiple times. It's a holistic and comprehensive approach to estate planning. So first of all, what you'll get is the family wealth trust. That is a revocable living trust, at least in most instances, that protects the family, and so the children and the surviving spouse, and provides multiple benefits and protects against multiple dangers. It's a comprehensive replacement for a will. There is still included a pour-over will, and what the pour-over will achieves is, I talked about funding and how important that funding is. If there were, let's say, an asset left out of the trust, let's say 15 years after you set up the trust, you open up a bank account and forget to put it in the name of the trust. Well, there's a chance that could become probate property. And if so, well, we want to have a will, and all that will is going to say is, if it's out there and it's probate property, put it in my trust. And then the provisions of the trust reign supreme. Now, a trust is a great, in fact, it's the best disability planning document that there is. So let's say husband and wife are there, and husband becomes disabled. Well, the wife is still trustee. There's no interruption, no lack of continuity there. And so the wife just keeps on managing the assets on behalf of the husband as a trustee. However, even as a trustee, there are still going to be assets, let's say the retirement accounts, or maybe a utility bill is another example. You call a utility company, unless you set up that account, they're probably not going to talk to you. So we want to provide still a property power of attorney. That's your financial power of attorney. And that's another document included in the package. We also provide a healthcare power of attorney. And that is very different than your financial power of attorney. That is who can make course of treatment decisions for you if you are unable to make them yourself and unable to speak. And so along with that healthcare power of attorney is a HIPAA authorization. And that's so that your healthcare agents can receive the information from the doctor to make the appropriate decisions. And then lastly, there's what we call directive to physicians, also known as a living will. And that is your, for lack of better words, your pull the plug document. Do you or do you not want to be maintained on artificial life support? And so it really is a complete package that we offer that handles really most of the contingencies that you can think of. It's very well rounded. Now here's a great benefit to the services that we provide specifically at our firm. In fact, we don't know of any other firm that does this in the Houston area. So when you come in and get your estate planning done with us through the Legacy Wealth Planning, then what we'll provide you with, once you come and sign the documents, is a personalized video. And now this video is fantastic. Now, and at first blush, you might think it's impersonal. I promise you it is better than us giving you the information off in person. Now the reason what we provide a video is this video is about almost an hour long. And it contains not just general information about trust planning and how it works, but it is specifically tailored to your plan and talks about your plan. So let's just talk about the old way that we used to deliver trust. An attorney would sit with you for about 3.5 hours and go over every provision of the trust, and you would walk away basically brain dead because of all the information that was dumped on you at one time. Now, with the current method, with the video, what you have the opportunity is you have questions, you just go back and watch the video. But even better is if your children have questions, which you should have conversations with your beneficiaries, your trustees, whoever's involved in your estate planning, they should know it before the day you die, because it is important that they be prepared. All you have to do is show them the video, and you don't have to take it upon yourself to explain all these legal facets of estate planning. You just show them the video. And if they have questions, in fact, we host families to watch the video in our office, just so that when they're done, they can all ask an attorney questions about exactly how it works. Again, that goes to the fact that we really do care about this working for you. We wouldn't, open up a conference room for you and have your whole family in just to watch the video, which we don't make anything off of, if we didn't care that your whole family knows how this thing works and that it does work for your family. And so we really do take a lot of pride in having clients where we deal with generation after generation of family members. Now, of course, none of this stuff is free with estate planning, especially for the services that we provide. And we talked a little bit about the bare bones planning earlier and some of the pitfalls associated with it. So a lot of people, and we know this, everybody loves a bargain. So, if I can go across the street and get gas for a cent cheaper a gallon, I'll probably do so, because a gallon of gas is a gallon of gas in most instances. But there are instances where you do not want to look for a bargain. And so I just want to give you a couple of examples of that. So number one, parachutes. You don't want to find the cheapest parachute. Surgeons. Probably not a good idea just to seek out the cheapest one. But here is the one that I really think is most appropriate, is fire extinguishers. If you go to the store and pick out the cheapest fire extinguisher that you possibly can, well, are you going to go home and test and make sure that fire extinguisher works? Of course not. You're not going to spray it unnecessarily. You're just going to stick it under your cupboard, and then what you're counting on is when it's needed, it's going to work. Now, that is not the instance where you want a cheap fire extinguisher. You want a quality fire extinguisher sitting in that cabinet so that when the time does come, you know it's going to work. And the same thing is true with estate planning. You're not going to know if it works until it's needed. And that is why it's so important to have the quality documents and quality, really, team behind you that we represent to provide you with that certainty. With that certainty comes a lack of anxiety. So many clients are so concerned that they just come in anxious, visibly anxious. And by providing quality estate planning and really showing that we care about them and that we care how these things work out for them, they almost always walk out the door with a sense of calmness that they did not bring when they walked in. And so I just want you to think about that this is not the area to look for a bargain. You want to get this stuff right, because you're not going to know if it went wrong until it's too late. So having said that, so some of the things that we've talked about today, of course, our main thrust is that our family wealth trust, our family wealth planning, is our most comprehensive planning, and we think that is suggested to almost all families. Now, that's not always true, and I'll talk about that in a second, but for families who find that incapacity protection, so disability protection, is important, that avoiding probate and extra taxes is important, to those who think that divorce and remarriage protections are important, and those who think that providing protections against creditors are important, well, that's the kind of couple or the kind of individual, it doesn't have to be a couple, who we would recommend for a family wealth trust. And we don't offer any surprises here. I mean, we're a planning law firm. We want you to know the facts in advance. And so we are very clear on our pricing. Our price for the family wealth trust is $4,795. And we don't charge by the hour. And that is our cost. We've been doing this for 26 years now, at least the firm has, not myself. And there's a firm understanding of what needs to be done and what level of time commitment from us that's going to require. And so we know what our price is, and we feel very confident in it. Now, if there are, so the $47.95 includes everything I mentioned in the trust package. So your revocable living trust, your pour-over will, healthcare power of attorney, financial power of attorney, HIPAA authorizations, directive to physicians, and assistance with funding, substantial assistance with funding. Now, if there are, it also includes one deed. So typically your average family owns a home who gets a trust. And so what we would do is deed their home into the trust. Well, let's say there were multiple pieces of real estate. Well, then we'd have to do multiple deeds, and that would add some cost. Additionally, if there is extremely specific language, whole paragraphs of custom language based on some very particular desires, we might need to charge a little bit extra for that. But in 90% of the cases, $47.95 is the cost, and $47.95 is what the client pays. So we are very upfront about that and feel very proud about that. Now, I mentioned a living trust is not always what's recommended. We're going to sit down in a consultation, spend about an hour to an hour and a half, free of obligation, and have a discussion about really what is the best option. So our gold level is the revocable living trust, and that is $47.95. However, we do offer will packages, either complex wills or simple wills, and the price really varies upon what language is in that package. Now that's good for somebody who really doesn't need quite all the horsepower of a revocable living trust, but still needs some sort of planning put in place. A great example is, let's say, a very young couple who just had their first child and maybe just purchased their first home. Even if they hadn't purchased their first home, they should have a will because they need to appoint guardians for that minor child. Well, we're not going to push them on a revocable living trust that they're just not at that point in life right now. So we would offer them and suggest a will package. So we really do go through the consultation and sincerely look at what your needs are and advise you on the best option based on cost and what's provided by the package and what your needs are. Now, the nursing home protection, Medicaid planning, that's a whole sort of different consultation. It's a much longer consultation. It's very, very fact specific, which is a good thing because we really got to dig down deep for these issues. That's a whole different sort of planning, and the pricing is based on whatever is prescribed by that meeting. But typically it's about a month and a half to 2 months worth of nursing home care. So as long as the loved one stays in a nursing home for 2 months, it pays for itself. It's a great value proposition. And then imagine what they stay there for 2 years. Well, heck, that's a great deal. All right, so as we conclude, I just got to warn you, please don't let this be you. Don't get caught with your head in the sand, knowing that there's a problem, but not addressing it. And even worse, as funny as it is in the picture, nobody wants to be remembered like this guy. And so you got to ask yourself, is this a duty that I'm willing to let go by, and that I be remembered for really leaving a bit of a mess? So that brings me also to this great quote by Pablo Picasso, famous artist, of course. But I love this quote: "Only put off until tomorrow what you are willing to die having left undone." That's fantastic. So you got to ask yourself, is this a duty that you're willing to die having left undone? Or is it something that you want to take the time and address now as opposed to procrastinating, thinking that it'll get taken care of later? And honestly, this is not a scare tactic by any means. It's just the truth. Someday there will not be a tomorrow. And so we never know what that day is. And that's why all of this is so important not to procrastinate upon. So what I hope that you'll do is go ahead and take that first step. And that first step is just giving us a call to set up a consultation. And so our number is 281-448-4100. We have a brand new office located just east of 249 on Cypresswood. We'd love to have you, but we can also do appointments on Zoom as well as over the phone. And it's a no obligation consultation. It truly is no obligation. There's not a lot of things like that out there. All that we ask is that if you say you're going to come, show up, and we'll have an open and honest conversation, and just come in with a willingness to really discuss what is most important to you. Now, we know that, like I said earlier, everybody loves a bargain. This isn't exactly the place to look for a bargain when it comes to estate planning. However, we do appreciate that you all joined us today. And so in appreciation of your attendance today, what we'd like to offer you is a educational credit certificate. And that certificate is good for $250 off of any new trust, or 5% off of any other planning. So let's say you had a will or maybe some sort of deed work that needed to be done. Anybody on the call today can take that discount, and you just have to present your certificate, or even just mention to us that you were on the call, and we'll be able to figure it out that you were there or not. Now, I say all that, and it's a great opportunity. I do want to make a couple of conditions on when you can use this certificate, because we found that, well, we want these consultations to go smoothly. It's a free consultation, and we want it to work as well as possible for you and us. And so we do ask that, well, when's the best time to work on something after you just learned about it? Well, pretty soon after. So we ask that you have your appointment within the next 2 weeks to be able to use your certificate. At least book it within the next 2 weeks. Also, if you're married, we ask that both spouses attend to be able to claim the certificate. Trust me, I get it. There's a lot of marriages out there or couples where one individual handles a lot of the financial aspects compared to the other. However, we have found it that these consultations work much better if both spouses are there to provide their input, and we represent both spouses equally. Lastly, we ask that you make a decision, a yes or no decision. Procrastination is just the worst when it comes to estate planning. And what we hope is that by providing you with a free consultation to discuss all these issues, just that you do us the courtesy of providing us at the end. I'll ask a simple yes or no question. Either I or Mr. Bond will ask a simple yes or no question. Do you want to proceed with us today or not? And we just hope that you will answer with a yes or a no answer, as opposed to let me think about it, or let me check and see, or let me ask my children. This is ultimately your planning. And if it's a no, trust me, there are no feelings hurt. I've been told plenty of times. But a no is a clear-cut answer that helps us know. In fact, this is a business or relationships. If you tell me no, that's fantastic. I got to meet you and you got to meet me. And we'll probably both be better off for having spent the time with one another. And so if it's a yes, though, well, then we're going to go ahead and get right to work. We're going to schedule you with a couple of more meetings. We're going to work on getting the appropriate documentation recorded, and we'll really get moving on getting you to the next phase of the planning process. And so that's all we ask for to be able to use your educational certificate, is that you schedule the appointment within 2 weeks, that if you're married, both spouses attend, and that you provide us with a yes or no answer at the end of the consultation. And remember, a no is just fine. This is no pressure. It really isn't. All right, so as we conclude, I really just have to ask one last thing. I hope that, well, was this worth joining today? I certainly hope so. I hope, during this rainy weather, you guys enjoyed yourselves and got some benefit out of this.